Hi, welcome again to Red Flags Rising. My name is Mike Hunnicky. I'm the co-chair of Hugh Subert & Reed's Sanctions, Export Controls, and AML Practice Group. With me, as always, is my good friend Brent Carlson, a director at the Berkeley Research Group. Today is Wednesday, July 9th, just after 2 p.m. U.S. Eastern. Brent, great to see you again. How are you doing today?
Great, Mike. Great to see you and glad to be here and talk with you today.
Well, Brent, there's been a few developments in the news, actually on the enforcement front, that we wanted to look at, not just to walk through the words used by the authorities in a few settlement agreements that we've seen, but really at a high level unpack those and explain what are the practical tips, not only in how to interpret these decisions for their own sake, but what do we think these decisions show about where export controls enforcement is likely to be heading as we work through the summer and into the fall?
Let's be honest. The two cases that we're going to talk about, at first glance, they're kind of dogs. They're old. The underlying transactions are 2019, maybe 2020 vintage, so they've been sitting on somebody's desk for a long time. There are very few transactions underlying, maybe in the teens on one, a few in the other. They're all EAR 99 items and the penalties are low. So who cares? What's going on here? Now we're in a period where there's a sense of a lull. Everybody in industry and in practice is waiting to see what's going to happen next in terms of compliance and enforcement for export controls. It's always the quiet comes before the storm. There's a lot of things going on in the backfield, and there's a lot of things underlying a new momentum that we're seeing. This is where, if we take a look at these cases, there's some important signals there. And one thing that really stood out for me, Mike, was your comment that you made on a post last week when we were looking at these cases. It's basically following the old FCPA, the Foreign Corrupt Practices Act enforcement playbook. BIS is messaging to industry through these enforcement actions what is going to emphasize next. These are the key takeaways from these cases.
Yeah, Brent, these cases are short on facts, but long on lessons. I totally agree with you. In my first review of them, well, look, there's not really a lot of facts articulated. Frankly, even from a knowledge perspective, which is our favorite topic, as our listeners will know, when you look at the facts themselves, these are actual knowledge cases. This isn't a controversial leap forward in theory or interpretation by BIS applied to these specific facts. But in the cases, BIS is emphasizing the full definition of knowledge, and in doing so, really setting up what's going to come next. They are previewing, as was done by the DOJ fraud section over and over again back in the era of heavy FCPA enforcement, what's the next thing going to turn on? These cases, when you look at the fact patterns, there's a sense of clearing the decks here. These are cases that may have been sitting around for a while, but they're using the opportunity of closing out some of these old cases to emphasize what's important to them about the regulations for the next case and for the open, ongoing cases.
Let's jump into the cases and unpack what are the signals from the noise in all this. So maybe, should we start with Alpha Omega Semiconductor?
Don't we have to start and end with that one?
Yes, that's right. It's like we shall start and end with this. The settlement agreement looks like it was signed June 24th. The company disclosed an investigation way back in February 2020. So again, this has been sitting out there for a while. The underlying transactions are 2019 vintage. The company designs, develops, and supplies power semiconductors for a range of applications, which we'll get into. These are EAR 99 items. Basically, they were going to Huawei just after Huawei got onto the entity list.
It seemed to me, Brent, to be a pretty straightforward actual knowledge case.
You made a really good point in the post that AOS knew or had reason to know, including the awareness of a high probability that a violation of regulations occurred, was occurring, or was about to occur. Let me read that point again. Including the awareness of a high probability. BIS didn't need to include that in here because this is really an actual knowledge case. What are your thoughts on putting that language in? That seems like a signal, a clear signal of more to come.
It certainly does, Brent. It certainly seems like BIS, for example, might be still thinking back to the Senate PSI report from December 18th that we've talked about a few times, where the Senate said you need to be using the full definition of knowledge. And there was a footnote in that report that noted that BIS officials, when they had briefed committee staff, had told them, at least before the July 10th guidance of last year, that they hadn't actually brought an enforcement action on that theory. This case is not an enforcement action on that theory, but they are making clear to everyone, we are viewing knowledge holistically. We are looking at the full definition of knowledge. In this case, as we've been saying, the knowledge was a little bit more straightforward. Don't do this, you cannot do this, and then they did it. But they're signaling to people in industry. They're signaling, frankly, to trade compliance teams who are looking for reasons why cases like this might demonstrate value in investing now on the front end of compliance, that the next case is going to maybe be on that high probability threshold, that it's going to go there, and that it's possible that cases could be just on that theory. This is very familiar to those of us like you and I who have experience with the FCPA. Why do law firms, why do consultants point to past settlements that other companies entered into when they're advising current clients about what might happen in the future? It's because this high probability standard is not scientific. In these cases, you have the government telling you, here's where we're going with this. And that's relevant to assessing and, frankly, perhaps reassessing compliance and enforcement risk going forward.
Well said. To quote from the BIS order in paragraph 7, second sentence, outside counsel noted in its guidance that it had not been provided with facts specific to the products AOS, that's Alpha Omega Semiconductor, intended to provide to Huawei. Let's unpack this advice of counsel defense a little bit. What are the issues around that, and what should companies and the legal and compliance teams keep in mind around that?
In the facts, you have the external lawyers telling the client, look, if you're going to ship these items from the United States to Huawei, you cannot do that. And then they did that. It's interesting to me that part of the factual record is what outside counsel told them. It suggests to me that there was at least some attempt to make an advice of counsel defense. And when they did, the government said, oh, okay, great. Well, if you're going to do that, not only do you need to show us the advice, but what did you tell your outside counsel as well? Advice of counsel defense is something that I think lawyers get a little nervous talking about. I'm feeling a little nervous right now. It's not something we really want to sell to clients, but in some ways, it's really why we're here. The whole point of having lawyers is really to get confidential advice, but be able to reveal it if you need to defend yourself, especially against allegations that you knew something or that you did something with an awareness or willfully knowing that it was illegal to do. Well, if your lawyers are telling you you can do something, that's a huge defense for an individual or for a corporation. That advice is only as good as the facts that you give your lawyers. We're maybe reading a bit much into the limited facts disclosed, but the key takeaway is if you want to be able to blame your lawyers, make sure you're telling your lawyers all the facts, that you're answering any questions your lawyers have, and that, frankly, you are comfortable with the footnotes in the memoranda that your lawyers send you, because those footnotes are there to protect the law firm. They're not necessarily meant to protect you. As a client, if you have any disagreement with your law firm about caveats, footnotes, or whatever, then ask about them in real time. Years later, here we've seen maybe 5 or 6 years later, when it comes out, it's too late to do anything about it. If now suddenly you realize that the advice you got isn't really going to protect you.
So it takes a little bit of strategic thinking in terms of how to put that together and thinking about how defendable this is going to be if the situation blows up.
Mm-hmm.
So we talked a little bit about Alpha Omega Semiconductor. That settlement agreement was released on July 2nd. Now let's turn to another case that we want to talk about, Unicat Catalyst Technologies, which was released just about 10 days prior to the Alpha Omega settlement. Let's talk a little bit of background and some key takeaways from that one.
Sounds good, Brent. This one's interesting because you're absolutely right from a BIS perspective. The press release and the public release of the settlement documents occurred on June 23rd. There's a parallel proceeding with OFAC. There's also a parallel proceeding with the DOJ's National Security Division. Those two get announced a week prior to that on June 16th. Even before that, if you look at the date this order was signed, it's back in December 20th of 2024. Who knows why? Obviously, there were a few intervening political events, but there's really interesting things about this case. There's a really interesting M&A due diligence angle to this one.
Let's go through a little bit of background facts and then unpack some of the key takeaways, because I think this is really interesting. There's an M&A successor liability angle, there's a due diligence angle, and then there's a post-settlement compliance program remediation angle to this as well. Again, this is an older case. These are vintage transactions from that same time frame, let's say 2019 and 2020. These are EAR 99 items. These are petrochemical catalysts used in the refining industry. The legacy company, before the private equity firm bought it, was selling these items into Iran. And they're doing so through an intermediary in Dubai, a classic intermediary structure. The US-based private equity firm bought the legacy company in September 2020. Coming into the deal, they did their due diligence. And it turned out that these transactions with Iran were not discovered, and they were only discovered after the private equity firm appointed a new CEO. The new CEO visited the company's headquarters in Texas and found this out. Immediately when he found this out, he reported back to the private equity firm and its board, and immediately they jumped on it. They hired new outside counsel and conducted an investigation. From the settlement agreements, it looks like within a month, they went and they disclosed this to OFAC and BIS. So from that perspective, they did the right thing. We can talk about leveraging the U.S. government's M&A successor liability policy. But one thing I think was interesting in here, and this goes to our first takeaway talking about effective risk-based due diligence, is that these transactions with Iran were not uncovered in the due diligence process.
Well, Brent, this one gave me chills, and probably anyone who's been involved at all with pre-acquisition due diligence, you would have the same reaction as well. We're all familiar with the dreaded virtual data room. These things are monsters. At the end of the day, I think regulators appreciate that from a buyer perspective, you are really a hostage to the seller in terms of what they disclose to you and when. In representing a buyer in these acquisitions, counsel, consultants really have two primary objectives. One, make sure you're at least asking and documenting the right questions, so that if they lie to you or they don't disclose things to you, at least it positions you to argue why you shouldn't have, as the buying entity, successor liability for whatever was happening at the seller. But you're also there to make sure that anything that is disclosed is reviewed in a thoughtful way to best protect the buyer. Because if something is disclosed, it's sitting in the data room, and it's not caught, then the regulators will have an initial impression that you should have caught the issue before closing and not after. From a business perspective, missing something also makes it much more difficult for the buyer as an organization to value the deal properly and to plan properly for post-merger integration, PMI as it's often referred to, of the bought entity into the buyer's compliance program. Now, that was my initial reaction. When you look at this carefully, it's very deliberately worded. What we do not know, for example, are several facts that would be relevant to the adequacy of the due diligence. We do not know whether on the face of the agreement it said intermediary. We don't know if on the face of the agreement it said Iran as the geographic scope. We do not know what instructions there were from the buyer or what requests there were from the seller about managing the workflow of various advisors who may have been involved. It's very common for sellers and buyers to try to focus the time and effort of their consultants, of their lawyers, by topic with reference to folders that are in the data room. Now, my personal view is to really do trade compliance due diligence, to really do anti-corruption due diligence. Someone with experience needs to at least float through the entire data room and see if there's that type of data there that may not have been flagged as relevant, but is relevant. So we don't know any of that here. We certainly don't see an allegation that the due diligence was deliberately sabotaged or was insufficient. It was very factual. The agreement was there. We don't know what was on the agreement. The agreement was not reviewed as part of the due diligence. As you pointed out, Brent, after this relationship with Iran was discovered, absolutely the right thing happened from the government's perspective. Obviously, they cooperated against the former CEO who knew that this was happening and has a separate plea agreement and will be sentenced at some point in the future for crimes that he's admitted to as a result of this. From a signaling perspective, this is the National Security Division saying, we will reward you with a declination if you come forward and report to us criminal activity that you discover even after closing.
For private equity buyers and strategic buyers, it just makes good practical business sense to do so. No buyer needs to carry the water, needs to carry the past sins of a legacy company, and you reflect it in the purchase price. This is a success story here for the private equity firm. This is where government and industry can really come together because it makes practical business sense too.
And even where you find something, let's say, short of something as egregious as these facts suggest here, right, where the CEO knew that there was an agreement in place to sell to Iran, you might only find red flags suggesting that. And you may have real limitations in your ability to press on those points and to get what you might consider, and frankly what the government might consider, to be adequate answers. But for experienced M&A practitioners, there's then all kinds of tools you can deploy to help protect the buyer in terms of costs, in terms of disruption, whether it's escrow, whether it's RWI, reps and warranties insurance, whether that impacts the earn out for the executives in particular post-transaction and how long that might take and what those conditions might be. There's a lot of things you can do to still go forward with the deal, but at least take a decent shot at protecting not only yourself from liability, but your money, protecting yourself from the unanticipated costs of something that might be an issue, but you can't really bring to ground that turns out to be an actual issue post-closing.
We've talked about the full definition of knowledge under the EAR, and you can see the signals that are coming from the government in terms of applying that full definition of knowledge, which includes an awareness of a high probability. If you're coming in as a buyer and you're looking at the legacy company operations, if they're drawing a blank in terms of how they're applying the full definition of knowledge under the EAR, if they give you a blank stare, deer in the headlights, where you go, what's your high probability protocol and how are you rolling that through your compliance program? Okay, that's not something that's going to set the alarm bells off necessarily there. This is not actual knowledge of an issue. There's a compliance program issue that needs to be remediated and fixed and reflected in the purchase price, because you can see where enforcement is going, where those signals are. Again, this is water that a buyer doesn't need to carry at all.
Brent, that's a great point. One thing that came to mind as you were talking about how the buyer might think when they're stress testing the seller's or the target's compliance program. You mentioned, does the seller's or the target's program consider the high probability standard or not? Now, they may say it does, they may have it in writing somewhere, but how would you really know? One example that just jumps to mind right now, how are they treating the end use and end user catch-alls? Those things turn on knowledge in a big way. If their program is entirely focused on item classification, and if you ask them, well, okay, great, what about General Prohibition 10? What about end use and end user catch-all provisions? How are you testing for risks that those might be in play? And they give you, in your words, Brent, the blank stare back. That's a huge red flag.
And again, from the buyer's perspective, it doesn't mean there's no value there. It just means that the value of the deal needs to be priced accordingly with where those risks are, what they may potentially bring, and what would it take to bring it up to standards with the current geopolitical realities that we have today.
Yeah, in an extreme case, and I've been part of deals where this has been done, the buyer could even force the seller pre-close to be the ones to make the disclosure themselves. It's not absolutely necessary, but it's one way to make sure that the target's name or the seller's name, if it's different, is the one in the headlines and on the documents and not the buyer's name.
This discussion points to the other key takeaway from this Unicat example, the compliance program remediation requirements as part of the settlement. I thought that was really interesting. BIS's settlement document refers to the OFAC one, and the OFAC one is the one that has the details, and we'll put these all in the show notes. But what I thought was really interesting is that it's a really thorough outline of what needs to happen. It's a 5-year commitment that covers key areas, and it's detailed in the OFAC settlement agreement from management commitment, risk assessment, internal controls, testing and audit, training, annual certification to the U.S. government authorities. I think perhaps that's another sign of what's coming forward as well in future enforcement cases. We had a recent pod, we talked about monitoring what matters and putting in that post-settlement monitor type or testing type of role. This makes it even more complete and has all these elements of a compliance program that really reflect the DOJ's evaluation of corporate compliance programs.
Brent, we've talked about convergence a lot, and we've talked about how trade compliance professionals can help their companies, help their stakeholders identify where there are areas of convergence that can be leveraged because they already have expertise, for example, in different teams or from prior experiences that might not relate to the immediate issue they're facing. Now, I think for a long time, OFAC has had guidelines that largely track the DOJ guidelines that largely track even the U.S. Sentencing Commission's guidelines for sentencing of business organizations. All of these things already, I think, converged, but it's a helpful reminder to trade compliance teams, but also to other people within your companies, if you're on a trade compliance team, that, look, we're not having to think about how we calibrate our compliance program to 5 different standards. It's all really converging. It's all coming together. The good news is that if you're focused on root cause analysis where there are problems, if you're focused on risk-based due diligence and risk-based compliance, you're going to go a long way, if not the whole way, to meeting DOJ, Treasury, and Commerce expectations about your compliance program.
So, Mike, we've talked about knowledge, we've talked about successor liability, we've talked about due diligence, we've talked about post-settlement remediation. Taking these two cases together and looking at them, what's another big picture takeaway when we talk about convergence and looking at past historical experience that may illuminate the way forward?
Well, Brent, it's interesting. Looking at my and your experience with the Foreign Corrupt Practices Act, whenever there would be a few cases coming out in a row, there'd always be a question about, well, is there a trend to be discerned from this? Is this a precursor of more to come? And how might one think about what is the more to come and where it might be? When I was a much younger lawyer, I remember writing many client alerts, many articles, and advising many clients about the potential for sweeps. In the FCPA context, these were often talked about as industry sweeps. The idea being that, for example, if the DOJ had determined that an oil company or an oil and gas company or someone in oilfield services had used a particular agent to bribe a public official in a West African country, they would look and see, well, are there 3 or 4 or 5 other competitors to this company over whom we might have jurisdiction? Let's see if they were using the same agent. And a lot of times they would be. In some ways, when you look at commerce and leading edge AI capability, that was the focus of the May 13th guidance and policy documents that we've talked about, and then look at these cases, not for the facts themselves, but what might they portend about the future? I started instinctively thinking about sweeps. What would be the sweep in this context? It would be a stack sweep. If you look at the stack for leading AI technology, the data centers, the GPUs, the racks, the cooling mechanisms, the packaging and testing, the modeling, the inferencing, all of these things, if you think about the end use and end user controls, as we do, Brent, as being really what we expect to drive future export controls enforcement, once any part of that stack is being used by an improper end user or for an improper end use, it would be very easy for commerce just to roll up the stack. Just as in the FCPA context, the DOJ might have rolled up an industry by looking at the same conduct and the same issues, and the same in that context, due diligence shortcomings. Here, if one part of that AI stack goes to a bad actor or for a bad purpose, and that AI stack is front and center from the U.S. perspective in terms of national security priorities, what we might start seeing are these stack sweeps up and down this technology stack, up and down really the entire stack for not only the training of AI models, but the running of them and the application of them to prohibited uses, military intelligence, WMD, the exact same end uses that BIS harped on in the May 13th policy and guidance documents. In the old FCPA world, if you had a client who was in an industry where somebody else just got hit, the first thing you would do is say, check your plumbing, check your compliance program, check your third-party relationships. These people just told the U.S. government that consultant A, business practice B, whatever it might be, were corrupt and were corruptly done in order to influence the wording of business. You need to know quickly whether you have that same type of exposure. Then if you do, stop the conduct and then evaluate, given that there's this public enforcement action, do you voluntarily disclose to get ahead of it or not, depending on your comfort level with that and your appetite for enforcement risk. But that would be exactly what the DOJ wanted you to do in that context, and that's what they were hoping people would do by signaling that publicly through these settlements. I'd expect Commerce and Justice and Treasury here to be doing exactly the same thing.
So if your products or technologies show up anywhere in the tech stack that's going into these AI data centers, watch what's going on in terms of enforcement actions, and then take action accordingly.
Absolutely. And pay very close attention to other policies that we expect to come out at some point.
Going back to the focus, shifting from the technological parameters, the item classification itself, to end user, in the context where it triggers these catch-all provisions. Even if you got an EAR 99 item, that's something within that entire tech stack. From the government's perspective, that's really easy pickings.
You know, Brent, one last point to make on this stack sweep idea. Why are sweeps so effective? One fact is because government has at least a view as to what it thinks are the topologies of misconduct, the types of misconduct that are red flags that indicate this high probability risk of something being diverted in violation of the export controls. The other fact is that whoever they go after first likely is going to cooperate with them. And frankly, if you look at these settlements that have been recently announced, DOJ especially, but also OFAC and Commerce are going out of their way to try to show value for cooperation. If somebody in the stack is going to start cooperating about how all this was put together, and if there's information that suggests that more than just that entity knew of the end user involved and potentially improper end use, to really build off what you said, Brent, that's the easiest of easy pickings for the government, because any precision, any documentation they need, any context they need, they have now a cooperating entity and or individual who has a requirement to provide them whatever they ask for. And that's how they can build their case against other people up and down the stack. Well, Brent, I think that brings us to managing up. Lots to talk about today. Again, these two cases were short on facts but long on lessons. It's been valuable to walk through what those lessons are in particular. At the end of this discussion, what is your managing up tip for trade compliance professionals this episode?
It's always the most quiet before the storm. There seems to be a lot that's going on in the backfield, even though we're all waiting to see what's going to happen next. Nevertheless, there are signals here coming from BIS. Now is the time to get ready. Knowledge is coming. So start talking with those who can help. Start to, if you haven't already, develop and implement a high probability protocol, because now is the time for each company to adapt to the new compliance and enforcement environment. Legacy approaches just no longer will work. It's time to get ready now. Knowledge is coming.
Why have that high probability protocol? Because that's the best way you can defend your company and yourself against an allegation by the government. If you can show not only that you were aware of that risk and that you genuinely and effectively mitigated that risk before proceeding, or if you couldn't, that you applied for and received a license, that's a great defense to be able to have to suspicion or allegations from the government about your intentions, your purpose, your willfulness, and lack thereof.
Especially if we see penalties increasing. BIS, the Commerce Department, Secretary Lutnick has been signaling that penalties are going to go up. I don't think penalties are going to stay in these low ranges for a lot of folks any longer. It makes that even all more important.
Well, Brent, that concludes this episode of Red Flags Rising. As always, it was a pleasure. Be well.
Thanks, Mike. Be well.